Thanks everyone for joining us this evening. We started this series of webinars, the Connecticut Charter Schools Association, about 3 weeks ago, although it sometimes feels longer than that. And I hope that everyone is doing well and staying safe. I know you're all sort of thinking in reopening mode and really working towards that. And we really appreciate all of your work as you're working through really some truly unprecedented times. So just wanted to introduce myself and the webinar for this evening and our panelists. So I'm Jan Menon, and I oversee policy and government relations with the Connecticut Charter Schools Association. I am joined today by Matt Plain and Tim Groves. They are attorneys at the law firm of Barton, Gilman. These are folks who have been doing this work for a long time in school law and specifically representing charter schools throughout the Northeast region. In addition to providing general counsel services, they also have engaged in litigation defending charter schools. So between the two of them, they're admitted to practice in several surrounding states: Connecticut, Massachusetts, Rhode Island, and New York. But between the two of them, they have teaching experience in addition to their experiences as attorneys and advocacy experience. Tim was a former ED for the Rhode Island League of Charter Schools. So these are folks who have seen the inner workings of our sector from multiple different perspectives and angles. And they are part of the charter school practice team at Barton Gilman. And they advise schools and organizations like ours from Massachusetts to New Jersey on a variety of legal matters. And I happen to know Matt through the Alliance of Public Charter School Attorneys, and both Tim and Matt are members. It's been, gosh, not to make you feel too old, Matt, but almost a decade since I've known him, and we've been a part of that group. So with that said, we have two basic components to the webinar for this evening. So we'll first hear from Matt and Tim, and then we'll talk through some questions. And you'll see from the title of this is the governance and board webinar. This is really about governing in this unprecedented time of a global pandemic. So one more logistical item, and then I'll turn it over to them, is that we will be hosting another webinar this Thursday at 10 a.m. in partnership with Charter School Business Management. That might be a name that some folks are familiar with. They are experts in charter school budgeting and financial management, so they will be providing guidance and recommendations in that context. We know that school budgets were due for the fiscal year, but we're hoping that this training will provide some extra space to think through some emerging issues and expenses, especially in this time of COVID-19. So with that said, I'd love to turn this over to Matt and Tim, and thank you both again for your time, and looking forward to the discussion this evening.
Great. Thank you so much, Jan. We really appreciate it. And thanks everybody for joining us tonight. We hope your families are safe and well. We appreciate the opportunity to be here before you. We appreciate you taking time out of your day. In addition to Jan's kind words about us and our practices, Tim and I also have experience serving on the governing bodies of the various different types of schools. So we appreciate everything that you folks are going through, especially during these times. We also are both the parents of public school students. So on behalf of public school parents all over, thank you for everything you're doing to ensure that students can receive a safe and appropriate education come this fall. We're going to spend a significant amount of time tonight talking about the meeting component of governing, because as you're all well aware, one of the most important functions you have as a group is to get together and decide the strategic direction, the overall custody, care, and control of your school that you govern. And one of the ways, or the most important way you do that, is through your meeting. And you're required to do that in the bright sunshine for the public to view. And that, in addition to being a requirement, that's also one of your most important communications you have to your school communities, to your various constituencies. And what we've seen since mid-March, when the governors of the various states where we practice instituted executive orders relaxing some of the in-person requirements for open meetings, we've seen increased participation 10, 20-fold in these meetings, probably for two reasons. One, with the uncertainty of where schools are going, folks are tuning in a way they just haven't before because they want to know what's happening and what the governing body of the various schools are doing about it. And two, they can attend now because they can plug into their laptops and their desktops or even their phones and follow along with what you're doing. We love that access. We love that the public, we love that your parents and guardians, we love that your school communities can participate. We've also seen an uptick in folks that are watching along or following along because they want to see what you're doing so that they can express to maybe your authorizers or maybe some others in the community about some things you may not be doing in full compliance. So obviously we're not going to give advice just to be safe. We're also going to suggest that you follow these things because it's appropriate and it's an important communication to your various constituencies. I'm pointing out that Tim and I are both lawyers. We're both admitted to practice in the state of Connecticut. However, this webinar is for education purposes only. We are not under a formal engagement with you fine folks, although that could happen. That's not happening tonight. So take what you've heard tonight, take it back to your various governing bodies, take it back to your school communities and contemplate these things further. If we can be of assistance down the road, please reach out, or please reach out to your counsel when various legal issues arise. With that, I'm going to turn it over to Tim, who's going to give you a 30,000-foot view and reminder of some of the extremely important components of your open governance laws.
All right, thank you very much, Matt, and welcome everybody. We have, it looks like we have an apparently a little hole in or maybe our first slide here, which is a good way to start, but we'll see if we can fill in those blanks. So the Freedom of Information Act, basically, as Matt alluded to, it's called the Sunshine Law, and it requires that everything be done, in the clear light of day. The key for public bodies, which charter school boards are, although sometimes, they can feel a little bit more like, a nonprofit board, and you've got, a lot of founders and parents and folks, who are coming together to do something very grassroots. So it doesn't feel necessarily like it has all the trappings of a school board, but it does. And so decisions of public bodies are meant to be made in public. And then the second aspect of the FOIA Act, the Freedom of Information Act, that we're not going to touch upon tonight is the access to public records component of it. But obviously, a lot of your open meetings generate public records. They need to be accessible. And that's a whole nother presentation. Right now, we figured we'd focus on some of the foundational aspects of and the basic overview aspects of the open meetings component of the FOIA Act. Because that is topical in light of the executive order that we'll get to later on in the presentation and the new, kind of brave new world of virtual school board meetings. But a couple kind of practice points without getting into the weeds. When we talk about the Sunshine Law and decisions being made, public bodies making decisions in public forums, fora, when you have, there are so many kind of benign kind of traps, seemingly benign practices that can generate a violation. You've got a group email and, it's more than a couple board members and they're talking about a decision. That's problematic because, you got a quorum interacting over email. That actually technically is subject to open meetings. You take your board retreat, and you go off to a nice place and it's just, it's cozy and it's insular. That's not in the bright sunshine. So just some things to think about, and we can get into this in the Q&A. Oh, there are my points. Sorry, I'm just a Zoom meeting novice. Getting on to our second slide. What does FOIA mean for charter schools? And when I say FOIA, again, we're going to focus on the open meetings aspect to it. FOIA applies to charter school board meetings. Does it apply to subcommittee meetings of the board? Yes, it does. Does it apply to administrative meetings? When it's, the leadership team, the head of school, some deans, et cetera? No, that does not. And CMO meetings, this is an interesting point, and the FOIA Commission, or the FOIA Commission, I guess, the FOIC, as I pronounce that acronym, made some rulings on this. The complaints were subsequently withdrawn before they kind of crystallized into actual decisions of the commission. But, the commission tipped its hand pretty clearly that, excuse me, CMO meetings are not typically the type of meetings that would be subject to open meetings laws. And the key inquiry there is the CMO acting as the functional equivalent of a public agency? And there's a 4-part test to that. Of course, everything in the law, there's always a 3 or 5-part test. This is a 4-part test. And the components are whether the entity performs a governmental function. The level of governmental funding is number 2. Number 3 is the extent of government involvement and regulation. And number 4 is whether the entity was created by the government. So on balance, and again, we won't get into the minutia, we can do that in the Q&A if anyone's interested. The Freedom of Information Commission in Connecticut determined that, no, this is not these CMO meetings. It's not the functional equivalent of a public agency. And so the open meetings law does not adhere in that context. So what does constitute a meeting under FOIA? Any hearing or other proceeding, again, hearings, Matt and I just did a teacher non-renewal hearing for one of our charter school clients. It was the first one I had done virtually. And so that was an interesting experience. That is a public meeting. That's, again, probably a whole nother presentation, and I'll try and keep it at 30,000 feet. But any other proceeding, convening assembly of a quorum of a multi-member public agency. So that's direct language from the statute. Any communication by or to a quorum of a multi-member public agency, whether in person, by means of electronic equipment, etc. So without just reading that slide whole cloth, that gets us to that email kind of potential pitfall that I alluded to earlier. If you've got that kind of electronic communication going on to and through a quorum of a public agency. So there's a whole laundry list in the statute of exceptions, what doesn't constitute a meeting, such as a personnel search committee for executive level employment candidates, and on and on and on. There are a number of exceptions, but basically, the rule of thumb is if this is a public agency making a public decision, it should be done in public. And those exceptions are going to be construed narrowly if they are reviewed by the commission or, God forbid, by the Superior Court if it gets to that level. So the types of meetings under FOIA, and again, I'm sure this is elementary review for most or all of you, so I'll go through it fairly quickly. And if, again, people want to drill down on questions, we can do that. So there's a regular meeting. You file your schedule of meeting, you post your agendas 24 hours in advance. There's a special meeting if you determine you have to convene before the next regularly scheduled meeting. So you have to provide 24 hours notice with the Secretary of State in that instance. And then there can be emergency meetings. And we can talk a little bit about or explore in the Q&A what constitutes a bona fide emergency. It can't just be that you neglected to do something at your last meeting. It needs to be, and the courts have said, take the plain language of emergency. It's got to be a real emergency. So we can flesh that out a little bit. But those are not for kind of, oh shucks moments where you neglected to do something or what have you at a regular meeting. Those need to be emergency meetings and for a bona fide emergency cause or purpose, excuse me. So notice, and these notice requirements, you post the Secretary of State on the school website, and again, January 31st for regular meetings, 24 hours for special meetings, as soon as possible for emergency meetings. And then, again, getting into the specific realm of, for example, a teacher termination hearing or something like that, additional notice requirements to the parties of interest would apply. So let's keep moving right along. I see I'm already burning through a lot of my allocated time, which is inevitable. Agendas, we touched on this a little bit earlier. You know, and key point here, key practice point here, you know, a meeting agenda must fairly apprise the public of the action proposed. And I've got a good anecdote here that I pulled that I just have to pull out because, you know, anyone who's been to a school committee meeting has probably heard something along these lines. It's a story from the Hartford Courant back in 2018. And I will call out, it was, you know, it was the Bridgeport City Council. It wasn't a charter school board meeting, but, you know, there, but for the grace of God, go we. And you know, they took down the transcript of the meeting, and a councilwoman just, you know, when people walked in, said, okay, everybody out, you know, and someone said, well, you have to make a motion. And then, you know, the lawyer said something that was inaudible on the transcript. It said, I make a motion to go into executive session for whatever he said. And then it was all in favor. And then, you know, they went into executive session. Again, you know, that is not a motion that fairly apprises the public of the action proposed, for whatever the lawyer said. And so for your agenda, you know, for your motion to convene into executive session, you know, you have to really kind of, you don't have to tip your hand too much, particularly if it's executive session and it would give away kind of the legal advice, counsel that you're seeking, or information about the property you're seeking to purchase, et cetera. But you do have to give something more than, you know, for whatever he said. So that's probably self-evident, but again, we've seen it more times than we care to recall. So that next, the meeting itself, you know, and this is a key practice point, whether or not you have a quorum present, if you go forward with the meeting, you know, you need to keep minutes, even if you're not taking any actions. Okay, so even if you don't, you know, it's weather, it's COVID, it's whatever, you don't have it's tech glitches in this day and age, or in this environment, you don't have a quorum present. And, you know, these are just some points that we can gloss over in the interest of time. Public comment, you do it first or last. All your votes have to be in open session. Again, public decisions made in public. If you have to add, if you need to add an item to the agenda, you can do that by 2/3 vote. Okay, again, that all has to be done in public, and there's a procedure that adheres there. And then 2/3 vote to convene as well into executive session, which requires a valid reason described with sufficient clarity. Moving right along, here are some of those valid reasons, and you probably have seen all of these before, so I will not read them verbatim, but there are a number of reasons. One thing, you know, one practice point again, you can't just kind of convene an executive session to talk to your attorney about something, you know, just saying seeking legal advice. If there is a written attorney-client privilege communication that you want to discuss, again, you don't have to divulge the nature of that communication. That would defeat the purpose and you know, and the privilege. But there needs to be that written communication. And then you can convene into executive session and, you know, colloquy with your attorney on that topic. The minutes, again, just some basics, which I'm sure you're all aware of, but you know, it's good to have a nice clean record, and you want to keep minutes. I won't steal Matt's thunder in this day and age of Executive Order 7B, even when you're recording your proceedings. So with that, Matt, I know I went over time. I apologize, and I'll stop talking right now.
No problem. Thank you, Tim. Thanks for the overview of Foia and the open meetings component thereof. Now, here's how the rubber meets the road with respect to governance amidst the pandemic. So as we all know, there's executive orders that now relax some of the in-person components or requirements for open meetings. And what does this mean for you folks? That means that you will now be able to, you are able to conduct your business through remote sessions. Those can happen by telephone or video conference. We have to just do those in a manner that allows the public to participate in real time. there's generally, Tim, could you go to the next slide? I think you have control of it. Thank you very much. So very generally, there's 5 components of this, and that's one, that your meetings can now be remote. And again, you can do that by conference call, you can do that by video or some other technology, so long as the public has the ability to follow along in real time. Those have to be recorded. And as Tim mentioned, even though you're recording these and making either a video recording or a transcript, nevertheless, you still have to have minutes. A recording and minutes are not the same thing. You have to have both in this instance. You also have to advertise and apprise the public, not only of the agenda like you would in the normal course, but also how the meeting will be conducted and how the public can access it. The documents that you plan to discuss during the course of your meetings have to be made accessible by the public before, during, and after the meeting. If that's put on, that needs to be put on your website, if possible, 24 hours in advance. We can envision scenarios where there'll be documents or reference in the course of your meetings that were not anticipated, and that perhaps you wouldn't be able to get them on your site within 24 hours of the meeting. Nevertheless, you're still required to get them available for public inspection as soon as you can, so that the public can follow along. Again, in the normal course, if a public attended the meeting of a governing body of a public agency and there were documents to be discussed, there'd be hard copies made available for the public. They take them, sit in the gallery, and they could follow along. Or those documents may be posted on a screen in a public library or something like that. Even though in this instance, or in these instances, we can share screens and things like that, nevertheless, we're still going to ensure that the public gets these things in advance. And then here's an important component that's also easy to slip up on, is that we need to ensure that the speakers, that includes the members of the governing body of the public agencies and anyone else invited to speak, are clearly identified prior to speaking. A challenge we have with that is when, in this instance, in our webinar format that we're in right now, it says Matt Plain under, in my video box, says Timothy J. Groves under his. We need to ensure that all board members, if they're logging on from a family member's computer and or using a family member's Zoom account, it might say Thunderbolts 93 or something like that, Avengers 94. I could do this for a while. Things like that. You want to ensure that has the name of the person that's intended to speak. That's one indicator that the public can tell who's talking. However, we're going to go a step further and ensure that the public definitely knows, and prior to speaking, you're going to identify who you are, and you're going to require your other speakers to identify themselves as well. In preparation for these meetings, Tim and I often remind each other that a practice tip that we pass along to our charter board members and the presidents and chairs of the same, that rely on the Robert's Rules of Order. And when you rely on those rules, it's obviously formal. Obviously, it takes a little bit more time in the normal course. We tend, once we get our sea legs and we go through a bunch of these meetings, some of the components of that tend to get skipped over. But if you call for a motion and John Doe says, John Doe, I so move. Jane Smith, I second. And then all those in favor signify by saying aye. In a normal course, everybody would raise their hand. The ayes have it. A practice tip that we're recommending in this, in order to comply with the executive orders in these instances, is that do everything by roll call. It may take longer. In fact, it will take longer. But if you have the governing body or the board clerk call roll, or somebody else assigned by the board president or the chair to call roll, it will make it more likely that you comply with this component, and that charter, or that folks from the public that are following along through remote participation can actually follow along. And keep in mind too, that in some instances, you're going to have folks that won't be able to view the video and maybe just listening by audio. So they want to know, they're not going to know everyone's voices, So we want to, again, clearly identify who those folks are when we do that. It will take time, but as you practice, and it is okay to get on early and just not discuss business, but to go through some of those components so that you can carry that out, that's fine. I think we all know this by now because these orders have been around for a few months, but this executive order pertaining to open meetings supersedes any conflicting requiremts in law, in your bylaws, in local ordinances, and any directives from your authorizers. In remote participation is permitted. How long that will go, we don't know, but we anticipate that this will go on into the school year. Again, it's critical that your written materials that your board's going to be relying on, that those are made available. We saw in the early days of this that board members, just like they normally would get emailed copies of the or attachments with all the documents in advance of the meeting, and then we get to the meeting and the public would get in either the chat box or the Q&A or some other function, or just email and says and indicate that they couldn't follow along. So that's something that we want to rectify. In fact, this executive order makes sure that you do that. And these remote meetings can take place regardless of whether there's a place for the public to attend. To keep in mind, though, we want to ensure that the public can participate and follow along. What are some barriers to that? Well, one is that you have a obvious type of technology that allows that to happen. Zoom, like we're using now, has been not only popular, but useful, and it's helped a lot with that. We've seen people use Google Hangouts. We've seen people use regular conference call. Whatever you use, ensure that the public, with a capital P, can participate. In the very early days in April, when we saw folks using Zoom, in some instances, they were using free Zoom sites or free Zoom accounts. The free Zoom account's great, and I use it to connect with friends from high school and college. I'm sure some of you folks do, but it would limit the number of participants. So if you were talking about whether schools were going to be open or not, and your entire school community was going to attend, and that free Zoom account or whatever type of system you were using or technology you were using didn't allow for more than 25, 50, 100, whatever it is, then some folks wouldn't be able to get in. Another component to this that you want to keep in mind is you can't require folks to open an account with a particular service in order to follow along and participate. That wouldn't be ensuring that the public can follow along and participate in real time. That would require them to take an extra step that they wouldn't have to take if you were holding your meeting in the proverbial public square. So it has to be free. It has to be something that's accessible. There's all different types of services that are allowing this now. Again, Zoom happens to be what we're using now. So I'll use that as an example. Zoom will have, there's a link. There's also a meeting number. There's also sometimes a meeting ID or a password in order to access it. If you're going to have those things, that's fine, but make sure the public can access it and make sure it's available to the public and it's part of your agenda before doing that. Also, a practice tip for things like using Zoom. Right now we're in the webinar format, and in the webinar format, you see what's called the panelists. And so the panelists have to be promoted to panelists by the host. And then there are participants and then there are attendees. Attendees are folks that can access, they can, in this case, view, unless you're calling in at least hear. But you won't see their video appear in a little box in the corner or in the front of the screen. You'll just see the folks that have been promoted to panelists. Again, in the early days when governing bodies of schools were using Zoom and they used the regular free account, we're not using the webinar account or access, which I think costs a little bit of money. We had the public, when they showed up for the meeting, they would show up just like a board member, just like the head of school, just like the CFO, and you could see everybody's screen. and we couldn't control, or at least there wasn't a host that was controlling who could put their video on and who could mute or unmute. So in some instances, we were having folks from the public who were chiming in at times that were not necessarily appropriate or welcomed. I'm sure you've heard of some of those instances. And then eventually someone figured out how to mute them, and then it was like whack-a-mole. And so we've seen plenty of that going on. Folks are getting better at that. If you're a governing body, that would typically have somebody at the school help with agendas, help with posting, help with disseminating information. When you had your meetings in the school library or the school multi-purpose room or some other public space that could accommodate the public, it is a great idea in these instances to engage the services of someone that has some facility with technology so that they can manage the technical component of these meetings while you folks are handling the substantive component. So you want somebody that can serve as a host, that can admit folks or promote folks to panelists if they're going to speak or address the governing body or the administration of the school, folks that can ensure that they can see when a member of the public, perhaps in public comment, has the hand raise function clicked so that you know that that person intends to speak. Again, if you had public comment in a regular meeting in the normal course, you may have a public comment sign-in sheet. And then the chair or the president of the board may just say, okay, here's my sheet. Jane Doe is going first. You have 2 minutes, go give your comment. Perhaps not as easy in this instance, so you'll have to just see who's going to make public comment. And what I've seen people doing is just looking in the attendee list and see who has the hand raised and then calling them in order, and that works. But either way, practically, before you continue to, well, as you continue to hold your meetings, ensure that you're using some sort of service that allows you to separate the governing body from the public. And that's the purpose of that, is so that the board can get to its actual business and the public can view the board undertaking its public business without interruption, and that the public is participating at the appropriate times. It's also, it may help as well when you post your meetings and you also apprise the public of how they can access it, that you have some sort of ground rules. Plenty of folks by now have participated in a meeting on Zoom, and so they might have an understanding of how it's going to go. And it might not necessarily go that way if you've set it up in such a way that you're going to separate the board. As panelists, you're going to have a host, and then you're going to have attendees. I know that I'm emphasizing that point over and over again, but that is critical for carrying out your business. It's critical for ensuring that you can get to all the important business that you have to undertake in the normal course, but particularly in these extremely challenging times. And also, it will make for a cleaner record. It's great that we can all participate in meetings like this. We're all dispersed throughout the Northeast right now, or at least Southern New England. And that's great. And so we can all be on, there's 12 of us right now, and that's allowing us to present and later to collaborate. But that also can make it challenging. Perhaps towards the end of this session, we get into a Q&A and we're all engaging in a discussion. When there's 12 people and there's not the type of moderator that you might have in a public session or a board chair that is calling on folks in a particular order, then it may be hard if you're planning to transcribe your meeting to follow along. It may be hard for the public to follow along, and it may be hard, even if there is a recording, to know who said what when. So again, it will seem a bit odd when you're going through it in that manner, to stop, to pause, to ensure that we're calling on people, that once you call on somebody, you're identifying yourself, that you're going through a roll call in every instance so that you can ensure that you're having that record that's clear and that identifies each person on each thing. But as you do it, you'll get used to it. At least that's our hope. And I think that as you go through this, you'll find that it allows you to conduct even more business in a shorter period of time, in that the usual barriers to conducting public meetings, or at least some of them, aren't there, because we have more flexibility in the way in which we can meet, because you can do it earlier in the morning, late at night. You don't have to worry in some instances child and things like that. So it's great that we're allowed to do this. It's certainly helping. But as you know, we're getting ready for the among the most interesting of starts of all school years, since compulsory education has been around for the last 100 years. So you will find, I can all but guarantee it, that you're going to have more folks participating in these meetings than you've had before. Some are going to be members of your actual communities. Some might be from other communities just to see what you're doing. Some might be supporters. Some might be on the other end of the spectrum and are looking to see ways in which you're perhaps not in compliance. So it's super critical to adhere to the strictures of that. So that's a lot on open meetings, and that's a lot on Zoom, frankly. But that getting the construct of this is extremely important, because without that, we don't want to negate any of the good work that you do, or render any actions you might take null or void because you didn't employ the appropriate procedures. And if we get into technical glitches as we go through these, in your administration, you as a governing body, and other members of your community were ready for the meeting, and for some reason that was related to technology, you couldn't conduct it, or it got interrupted because of the method you were using to deliver the meeting to the public, that would be unfortunate, and it may stall implementation of some things that are extremely important as we approach the reopening of school in early fall. So on that note, governance isn't just about the construct of the meetings and carrying out the meetings, but it's also about other components of it. And one big one is the reopening of the school that's coming up soon. So board's role in this, we want to stress that we understand certainly the distinction between governing body and administration, and we don't intend for anything that we deliver to you tonight to suggest that because we're in some pandemic and because we are permitted to participate and conduct meetings remotely, that the board is now infusing itself into operations. The line's a little blurrier now because everybody's got to participate in order to get this out fast, and everybody's got to participate meaningfully. Nevertheless, there's still the policy-making body, the governing body, and then it's administration, obviously, who carries it out. Nevertheless, the board's inextricably intertwined with the operations in that you control the direction. So on that, as we know, reopening plans we need essentially 3 different components of it. But some things that we're advising governing bodies of schools to keep in mind is, as your schools develop, submit, and redraft, revise, as these reopening plans evolve, you folks on the governing bodies of these schools must be aware of how these plans impact your policies. And those policies could be related to students, like student code of conduct, like student handbooks, like policies and procedures regarding parent and community access, or use of buildings, or participation in the delivery of education to students, or personnel policies. What do you require folks, what you don't require folks, how they're going to be evaluated, how they're going to interact with each other, with administration and the board, various things like that. So as you roll out these plans, you're going to want to ensure that your policies align as well. So to the extent there are a reopening plan component requires policy redrafting, you want to ensure you're doing that, because the policy is your way of communicating to your school community what the governing body, you as representatives of the school and the folks that set the a strategic direction or charged with care management control of the school, where you stand on a particular issue. So policies, obviously that's broad, in that there's a whole month education seminar we'd have to do on all the various policies that you'll have to review and possibly revise. But we just want to emphasize that as you continue to contemplate and cogitate on your reopening plans, that you're mindful of that. Regarding policies in another context, insurance coverage is something that you'll want to look at. Insurance is a contract, as you know, between the insured and an insurer. You likely have various insurance policies. You have directors and officers policies. You probably have premises liabilities policies. You probably have workers' compensation, student accident insurance, all these different types of policies, employment practices liability, and cyber security policies. Those things may have come up for renewal. The folks that you may delegate responsibility for interacting with brokers and signing those policies to your chief administrators in your school. Nevertheless, those are contracts between the school, which is you folks, and the insurer. So you want to make sure that you've looked at those, that you've been advised by perhaps your broker and certainly your school administration about your coverages and any adjustments you may be needing to make to those as you contemplate reopening.
Hey, Matt and Tim, I just want to flag us for time. We've got some key questions that are coming in, so we'd love to be able to get to some of those if that's all right with you all.
Yeah, sure. Can I have like 90 more seconds?
Yeah.
All right, cool. Thank you. So other things to consider, you're going to hear about student and parent requests for accommodations for different types of education or different delivery methods for education. There's a big difference between an accommodation that's made pursuant to an individualized education plan or a Section 504 plan and an accommodation with a little a that you may be making for a family that wants to do something differently based on their own unique need, but it's not necessarily an obligation. That you're going to have the same types of requests in the employment setting. You may have requests for accommodations from employees. Some may require them in order to fulfill the essential functions of their job. If they require them and you can provide that reasonable accommodation without it amounting to an undue burden, then you're required to do it so long as they can still fulfill the essential functions of their job. That's different than someone coming and saying, this is my scenario at home, I need some help, will you accommodate me, or can you do something differently so that I can continue to provide services and work for this school? That's something that will be administration's call, but that's something that you folks want to be mindful of as you establish policy. You must have a policy that says you don't discriminate. Of course, you're going to have that. Yet, at the same time, you want to make a policy decision about how or the manner in which you will contemplate requests to do something differently as we approach this. Governance and the liability component of it, that's again, we could spend a month on that. And I know in the interest of time, we'll just say be hyper aware of what's coming from your authorizer, be hyper aware with what's coming from the state health department. And some of the things that they suggest are going to be setting the standard for your school's conduct as you get ready to deliver education to children. So keep those things in mind. Talk to your insurance brokers about it, because I think we can expect a significant uptick in claims as we go into this next school year. So with that, we want to leave time for questions. Thank you for listening along to us, and we'll open the floor and for Jan, you and your folks to decide how we go about fielding those.
All right, thank you. Yeah, and thanks for this information. This is great. We have gotten in some questions from folks, and Kara is kindly putting them into the chat as we move along. So the first one is around Foia. So knowing that Foia does not allow for evaluations of teachers and school administrators to be seen, is the evaluation of the executive director or charter leader for a charter school in open session or an executive session, and is it subject to Foia like a public school superintendent?
Tim, you want me to take it, or that's what this? I'll take it.
Oops,
You're muted. I'll start. You chime in when I step in it. So under the open meetings component of Foia, you're permitted to go into executive session when you're talking about employment or performance. That doesn't obligate you, but it does permit you to do that. We advise folks that even though somebody might be holding a position that's a public position in a school that is evaluated by a public authorizer, that nevertheless there are personnel components of it that for privacy considerations you'll want to conduct in executive session, so that performance is something that is done in executive session, and that various things that would otherwise be personally identifiable and would compromise privacy considerations for an employee weren't done in the bright sunshine. That all said, if you're going to vote on maybe a salary increase or in renewing the employment of an executive director or some other leader, that's something that you'll do in open session, regardless of whether you conduct the discussion of their performance in an executive or not.
Great. All right, next one. A board meeting that is public must be recorded or could be recorded, question mark. Is this a mandate? And if we normally don't record meetings in person, why need to record now if we're allowing public access?
That's a great question. You have to, because the executive order requires you to. That's a short answer. And it's a recording or a transcript.
Right.
And once you make that recording or the transcript, then it's got to be on your website. And that's right in the executive order. Good question, because if the public can follow along and you wouldn't normally do it, then why now? Well, because that's what the order says. And that's been consistent across states for the most part, that we're seeing that. And I'm sure at least some of that is to allow for the public to get up to speed with how we're conducting these meetings. So if folks miss it, if there's maybe some folks that don't have that type of access where they can follow along in real time, or they can log on to Zoom or Google or one of the other various types of services that folks use. So it'll be there and captured so folks can go back to it or be provided with a recording at some point later.
All right, yeah, this next one sort of relates to that. Could it be written in the bylaws for electronic meetings to be allowed? We've never had more participation from our board before versus in person.
Yeah.
Great question. Go ahead, Tim.
I was going to say absolutely. I mean, I think it's, you would need to, there are provisions for that in the FOIA Act. You'd want to be careful, obviously, in balancing the utility. But if you're seeing an increased attendance, it's something that you may want to discuss when you've got, when we're out on the other side of this. And, I wouldn't do anything too hastily, but, certainly, and you'd want to have, there are some exceptions that are written into the executive order. You'd still need a physical place to convene, for example. I mean, that is a provision that the executive order relieves you of at the moment, but that's temporary. So I think, and Matt, obviously chime in, but I think it's an interesting question. And I do think, particularly with charter school, and maybe this is my limited anecdotal kind of insight, but my sense is, having been at larger district, public school district school committee meetings, tend to get a little bit more, typically more public attendance than maybe a charter school board meeting. And so if you're now seeing more, kind of public participation, I think that can be a very good thing. And anything you want to do to kind of continue that and cultivate that interest and engagement and involvement from the larger community, again, cuts both ways. Sometimes you can have your detractors there, who are kind of bird dogging you, but hey, if you're doing things right, then that's all going to be fine. Confer with council, obviously, maybe even have a subcommittee, take a look at it, revisit the bylaws, look at the appropriate, look at Foia, understand what the exceptions are that have been carved out by the executive order, and make sure you're in compliance. But it's certainly a topic worth considering if you feel like there's been a net positive coming up.
Yeah, and I'll add real quick to that. One, distinguish between public participation in board members actually conducting the meeting, and also, as Tim alluded to, we'd be shocked if the various states didn't, at a minimum, contemplate revisions to the open government laws to account for the extreme increase in participation, in frequency of meetings, which has been nice. You've had to meet, we get that, but I think we're going to find that governing bodies are less reluctant to meet frequently when they know they can do it from their home without commuting, without being out late at night or early in the morning. So we strongly suspect that those things will be taken into consideration, even when things we're capable of going back to the way in which we used to do these things.
We'll all be so good at Zoom by then, it would seem a waste to
yeah, right.
throw that
Yeah.
away.
All right, our next question. In regards to policies specific to COVID-19 that are adopted by the board, should they be removed after the pandemic, or should they be written to state a pandemic outbreak in lieu of the COVID-19 wording?
Can I give the classic lawyer answer to this one, Tim?
I was about to jump in with it, so go ahead.
It depends. It depends. You folks are rolling your eyes, I can tell. But it does. It depends on the policy. You will, in all likelihood, whatever policy that you put out to address our current state, or our current, the status of our schools right now, and the ability of all kids, faculty, and staff and administration to participate in person 100% of the time. In all likelihood, when things turn around and we go back, or we have the ability to go back to the former way, you'll probably have to look at those policies again. Obviously, you can put some language in there so that they conclude. They don't perpetuate forever and all time. They're just intended. The language indicates that they're intended just to address a particular situation. But I've kind of suggested it, but it's possible that even if it were able to go back to how we used to educate kids on March 11th and 12th, that we won't go back the same way, or that we'll infuse some of the components of what we've been doing now for governance, for administration, the delivery of education into the next phase of education. So either way, you're going to have to address those again. I know I'm giving you some foreshadowing of what to expect down the road, and that's a lot more work. But if somebody hasn't told you already, expect a lot more work. If you've been on your board for a significant amount of time, or even a year, or even since February, in the coming months, in the coming year, expect a lot more.
All right, and with our time remaining, we actually have one last question. Are schools legally required to allow for teachers to work remotely due to documented health or doctor orders?
I can start, Tim. You want to,
Yeah,
you can
yeah.
chime in, or
I think,
you go.
no, I was just going to reiterate kind of what you alluded to a little bit earlier. I mean, if there is, you go through this interactive process. If there's a disability, a medical condition, what have you, it's going to be a case-by-case determination. It's good to have good policies and consistent policies for the consideration and review of such requests. But where you have, and it's interesting in this context in particular, where you have from the State Department of Ed in Connecticut, a mandate with further, I guess, guidance to come, that if a family requests to have a student continue with distance learning, there's an obligation, that student is not to be considered truant. That student is going to, you're going to accommodate that student as part of your reopening plan and a hybrid plan. It's not the same, for a faculty member. There's not that default, accommodation implicit in any guidance that I've seen from the State Department of Education. And when you go back to, is it, someone who just says, I don't feel comfortable coming back, can I have an accommodation? Certainly, we want to, to speak with those people, give assurances, take it on a case-by-case basis. But I think the scenario that you envisioned with a doctor verifying a condition, then you're in a different kind of analysis, which Matt outlined a little bit earlier. And, can they perform the essential functions, without imposing an undue burden on the school? And if you've got a classroom full of students and a teacher who's not able to be there, these issues are challenging ones. And as we, think about our values as school communities and how we want to honor those, but at the same time, how we have to function as schools going forward, those are going to be some tough decisions.
Yeah, and I'll just reiterate some things that you stated because they're critically important. There's a difference between having a medical condition or disability and being uncomfortable. A medical condition or disability may require you to provide a reasonable accommodation if the reasonable accommodation would allow the person to perform the essential functions of the job and it wouldn't result in an undue burden to the school. Discomfort, not wanting to do it because of a personal preference, isn't something that requires an accommodation, though you may in your schools have administration contemplate it depending on the unique components of your operations. So definitely you want to ensure that you have policies that indicates clearly that you do strictly adhere to the Americans with Disabilities Act, the Age Discrimination in Employment Act, things like that. Something else, age isn't necessarily a disability, or age is not a disability, right. Though age may come with a disability, or disabilities may come with age, but in and of itself is not. So it's important to talk about these things at the board level, even though they're operational, because you want to ensure that your policies reflect not only best, but required practices for public schools.
Right. And age is a great one in this context in particular, because you've got the CDC, people over 65 are at a higher risk, yeah. In the environment with COVID. But the EEOC has issued guidance clarifying, that employers don't need to offer special accommodations to older employees, even if that employee, has probably a legitimate basis for that fear, that trepidation of coming in. And that sounds harsh, but that is just, again, knowing the contours of the law and what your legal obligations are as you go through what we think will be a case-by-case analysis with those types of requests. It's going to be difficult. It's going to be trying. But those are, again, Matt kind of touched on that analysis. What would be a reasonable accommodation? What would be an undue burden? And you only get there if you've got that, legitimate medical diagnosis of a disability that's going to impact their capacity to do the job.
All right, I know I said that was the last question, but we have just a question to clarify on the first question. Going back to the first question, are evaluations of employees foiable? I could be wrong, but I thought the superintendent evaluation was subject to Foia.
You know, I don't want to jump, go out on a ledge there. Maybe that might be one, Matt, unless you know specifically. I was on board with your answer before, but that might be something we can drill down on and follow up with.
Yeah, there may be agency interpretation of particular sets of circumstances. Whether that would apply to your executive directors or your charter school leaders, we'd have to look at the decisions that determine that particular components of an evaluation are something that are accessible by the public. Again, the actual physical document itself is something that's different than the actual discussion. So we were talking about it in the context of the meeting and when you could go into executive session. Documents discussed therein or that a result therefrom may be a different story, but that's a fact-intensive inquiry that you'd have to delve deeper. And so I don't mean to punt on that one, but I just did.
All right. Well, thank you both for your time and for engagement this evening. I just want to remind people quickly about the Thursday webinar at 10 a.m. on budgeting and financials. We hope you'll join us. A recording of this webinar will be available on our website at ctcharters.org. And if you have ideas for future webinars, we would love to hear from you. So feel free to email us with questions. And you'll see on the screen here, we also have contact information for Matt and Tim. These are some fantastic folks working on the front lines of the hottest charter issues in all the surrounding states and our state. These are folks that are really seeing what's going on. So you can reach out to them as well. So again, Tim, Matt, thank you so much for your time.
Our pleasure.
Really appreciate
Thank you
it.
so much.
My pleasure. Thanks, folks.
Thanks. Bye, everyone.
Bye.